Hello, my name's J.Tribe, and this is my short exposition of my paper on charity patrons in English and Welsh charity law. For some time I've been writing about various office holders, for example, directors of companies, trustees of trusts, and such like, and this has led me to consider patrons and the idea of patrons with charitable trusts and charitable companies. And I was starting to think, well, why do patrons benefit from kudos when they act as patrons of charities? Why do they get this associated kudos when there seems to be no reflective culpability if things go wrong? There seems to be no link between the patron and the charity on the negative side as opposed to that positive kudos side. So in this paper what I try and do is explore these points, and in particular that link about, well, can there be any recompense, for example, against a patron who perhaps is deep-pocketed if a charity becomes technically insolvent? Is there some kind of duty that a patron owes, or do they just exist in some positive way, as I've described, as just an office holder who benefits in a one-way street direction from their association with a charity? So my title, The Patronage Bargain in English and Welsh Charity Law, looks to the idea of this bargain, a bargain between a patron and, we'll call them a client, in this instance of course a charity, and how they interact. And that patronage bargain, as we'll shortly see, is the tool which I use in the paper to examine this unusual and special relationship. So here is my abstract for the paper. You can see that broadly the paper is divided into two main parts, although structurally there are actually three within the paper. But the two broad parts, the first is a historical exposition of patronage through time. And what you'll see as I run through the paper is that I explore various types of patronage over time to see what ingredients we can find in diverse fields such as art, literature and politics that evidence what might be within the patronage bargain. So that's the first main part of the paper. The second part, after the history of patronage has been examined, moves to a consideration of patrons in English and Welsh charity law. And in so doing examines what duties, if any, they have, and then of course attempts to show how two separate types of duty might appertain to patrons. The first being shadow director culpability if the patron is deemed to be a shadow director of a charitable company through their actions. And the second is trustee de son tort liability in a similar way, but of course if a patron has acted as a trustee in relation to a charitable trust as opposed to a charitable company. And that makes up the second part of the paper, the second main part of the paper. In terms of the structure, the first part is this historical exposition. The second part is broken down into that examination of shadow director liability or trustee de son tort liability. And then the third part really suggests ways in which we might make charity patrons liable for their activity if it is deemed to be culpable in the shadow director or trustee de son tort sense, if they owe a duty. And of course, on the face of it, we would say that our charity patrons do not owe duties in the same way that trustees do or indeed directors of charitable companies do. And that's the sticking point that we need to get over to establish any form of culpability for charity patrons, if indeed there should be any. So that's the paper in outline. Let's now have a look at some of its ingredients. So this takes us to the Patronage Bargain, which is a tool of my own creation, which is a novel aspect of the paper. And what the Patronage Bargain is a kind of portmanteau term that has within it the various ingredients that go to make up the relationship between the patron on the one hand and the client on the other. And in this instance, of course, the client is the charity that's registered in England and Wales as a charity with a charity commission. So when we're thinking about the patronage bargain, we can think, as the table demonstrates, of it containing a number of different qualities, ingredients, some of which fall to the patron in terms of the kind of benefits that they might get from the patronage relationship, some of which fall more to the client, so that the kind of upshot of the patronage relationship or the patronage bargain is that some of these types of behaviours or feelings or ingredients might be manifested for the client. And then some of the bargain elements, of course, are mutual between the two parties, between the patron and the client. So as you can see from table 1, there's a myriad of points, of ideas that flow from the patronage bargain, which I've gleaned or taken from the historical relationships that I've looked at between various patrons and their clients in art, literature, and political patronage. So as I've moved through various patronage relationships over the history of the subject, I've extracted these terms, these ideas, relationships and points, and included them within the patronage bargain to make up this portmanteau, this term that helps us think about what's going on between the patron and the client and why either party would engage in this relationship at all. So that's the patronage bargain. We'll use it as we progress through the paper to think about the patron and why they might engage in the charity, and the client and why they might think of themselves as being an entity that might benefit from patronage. So that takes us to part 1 of the paper, which examines the history of patronage and also the motivation for patrons to become involved in this patronage bargain relationship. And the 3 main areas that are examined in the paper are ecclesiastical patronage, literary patronage, and political patronage. Those 3 areas demonstrate the various ingredients that make up the patronage bargain. So elements that could be seen as both positive and negative for either the patron or the client, and also points that could be seen as mutually beneficial for both parties in this patronage dyad. What those areas also demonstrate, and in particular literary patronage, for example, is that the patronage bargain is not always beneficial. So, for example, William Blake in the early 19th century talks to the idea of patronage subverting his artistic activity, so causing it to go in a direction that was contrary to that which he wanted, feeling some kind of pressure to develop art in a way that was consistent with what the patron wanted, but not what, for example, William Blake wanted. So there are various aspects of these different historical points which are noteworthy for obviously the ingredients they give us for the patronage bargain, but also for various points that go against what we might think as the uniformly positive relationship of patronage. In other words, on occasion, patronage can have both negative effects as well as positive. The other main point that the historical exposition of patronage shows in part 1, and this is demonstrated here in the slide in table 2, is what patronage says about society more generally. What I've tried to demonstrate with the table in table 2, you can see there the ages of patronage and philanthropy, is that patronage and its deployment went with great wealth, generally speaking, great power. So we'd see patronage being deployed by members of society who were powerful and wealthy. So historically then, we see, as you can see from the table, the first major swathe of patronage comes from the monarch. So we see, both historically and of course in the modern context, as we'll see later, that the monarch has been responsible for patronage for a very long time. But as time progresses, as you can see from table 2, we start to see a shift towards the nobility. This is the blue column on the table, where the nobility, in a form of, I suppose, mini fiefdom expression, are able to also patronise various clients, most notably in the context of literary patronage and art patronage, where they're able to employ various artists and writers and help facilitate their careers through monetary contribution in the main to help those artists and writers create. So, for example, we have the Earls of Creation, who were able to facilitate the careers of a number of individuals in the artistic and literary sphere to create works that are, of course, now famous. And that then takes us, though, to the next stage in development of the ages of patronage and philanthropy, where we see the sort of yellowy orange bar in the graph, which is basically the rise of merchants, the rise of capitalism, a shift from feudalism with our aristocrats in the first green and blue phase, where we start to see the rise of the merchant class, who themselves are able to become philanthropists. And then, of course, in time, through the 19th century into the early 20th century, we see fantastic wealth amassed by some of these individuals, which is then used not just for their own benefit, but in a broader sense, in a philanthropic sense, and of course in a patronage sense, to benefit society more broadly through charitable donation. So we start to see a link between charity donors and charity patrons in some instances. In terms of the patronage bargain, this is interesting because of the kind of reciprocity that we see some of these philanthropists and patrons of the 19th century, these merchants, getting from their gifts or involvement in charitable activity. So, for example, Sir Henry Tate gave a lot of money to the University of Liverpool. As part of that activity, there are various plaques and designations of his name around the University of Liverpool that reflect that early philanthropic behaviour in the institution's life. To what extent was he minded, Sir Henry Tate, when he made those gifts, to make the gift through altruism or egoism or for some other purpose? Did he expect that his name would be reflected on a building in due course, or was he just being purely altruistic? For us in the patronage bargain, that donor intention isn't as important for this paper. That kind of activity can be seen in the work of my colleague John Picton, But here in this paper, what we want to see from Sir Henry Tate's activity, or what we're trying to examine, is the extent to which his involvement in patronage of the institution was for a reason other than purely benefiting the institution. Was he, Sir Henry Tate, also involved, invested to get benefit for himself as part of the patronage bargain? What was his motivation, in other words? And on motivation, perhaps the most interesting point that we could make in this brief exposition about motivation and the patronage bargain is royals. So why is it that royals become patrons? Is it to do good generally, or within the patronage bargain, is it a reflection of, for example, the idea that they should become patrons because they need to justify their drawings from the civil list? So there's a kind of quid pro quo to their relationship and engagement with patronage because of some financial gain. So that takes us to part 2 of the paper, which is relatively brief compared with the other 2 parts, those being part 1, the historical exposition of patronage, and part 3, the culpability examination. And there's a reason for the brevity of part 2. That's because basically there isn't much in the way of law that regulates patrons. So when one examines the books of authority and case law and statute, there's very little that's discussed in terms of how patrons should be regulated. And the main reason for this, of course, is because they don't owe a duty. So there's no duty upon which, on the face of it anyway, they can be This takes us to the third part of the paper, trustees, patrons and their duties, or of course their potential duties. This part of the paper is divided into 2 main areas. First, I examine trustees' duties pursuant to the Trustee Act 2000 and some other sources. And then I examine patrons specifically. And I break down my treatment of patrons into 2 areas that reflects the way in which charities can be constituted in English and Welsh law. So the first type of charity is charitable company. Charity set up corporate form. This is demonstrated recently by the Kids Company saga, which you may be familiar with. You'll have seen over the last 5 years or so various cases that the Secretary of State has brought against the directors of the Kids Company, which is a charity company, a charitable company. And a recent bit of litigation that in fact hasn't yet occurred was a case, or is a case, that's been brought by the Secretary of State for business to bring a shadow director claim against one of the participants in the Kids Company saga, and that's of course Camilla Batman-Jelly. Whereas other directors such as Alan Yentob were validly appointed, so he's a de jure director, Camilla Batman-Jelly, it's alleged, is a shadow director. So she's someone in whose guidance the board of directors was accustomed to act, according to the Secretary of State. So that's, of course, shadow director liability for somebody who allegedly acted as a director. To what extent might that idea, that area of shadow director culpability, be extended to patrons who have acted in a way like Camilla Batman-Jelly is alleged to have acted in relation to Kids Company? So if a patron instead of existing as some kind of overarching kudos attracting and donation attracting individual, has descended into the pit of logistics, of general day-to-day activity, and caused the charitable company, to act in a certain way which is problematic in Companies Act and Insolvency Act terms, does that mean that that patron can be accounted a shadow director if it's a charitable company? That's one area that's explored in the paper. The other is if the charity has been constituted not as a charitable company, but as a charitable trust. And in the same way as we've just explored with shadow director culpability, is there any way that a patron of a charitable trust could be accounted a trustee de son tort for any activity that they engage in with the company? So again, has that patron descended into the arena to behave and act like we'd expect normally only a trustee who owes duties, of course, to act, which means that that patron is affixed with trustee de son tort liability, meaning that they, of course, have trustee-like duties that are owed, and of course, if they've breached them, they will be held to account. So these are the two main areas that are examined in this part of the paper, in part 3. What they highlight is, of course, and this is the other main novel contribution of the paper, excuse me, is an inconsistency in how we deal with patrons depending on how a charity is constituted. So if at the beginning of the charity is decided that the corporate form, that's to say memorandum and articles of association as they then were, now of course the memorandum of association, for a company is used to constitute that charity, or if in the alternative a charitable trust is used with its relevant documentation, the upshot of those decisions, early decisions on constitution, could have long-term ramifications for any potential culpability of patrons, because you could argue that it is probably easier to bring a shadow director claim against a charity patron for any activity that they've done that's deemed to be of a shadow director nature than it is for other types of action, such as trustee de son tort liability. So if there's been some kind of insolvent episode that looks like, for example, some form of wrongful trading, and the patron has participated in advising the board to do that, it might be easier to make them culpable in terms of shadow director liability. So after examining those two areas, this third part of the paper then proposes a new patron personal conduct duty, because of course without any of the trustee de son tort or shadow director liability, it's a truism to say that patrons do not owe a duty. And of course, if they don't owe a duty to the charity, they can't be pursued for any breach of that duty. And that's the current position, of course, that when we think of patrons, we think of them as, in the patronage bargain sense, as this form of office holder that, in terms of responsibility, has very little responsibility. So this patron personal conduct duty is floated in the paper, is mooted as a way perhaps of reflecting the idea that, as suggested right at the beginning of the paper, it's inappropriate for somebody to have an office which gives them kudos, beneficial elements of the patronage bargain with none of the negative elements, and that there should be some reflection of that kudos. If it's okay for you to bask in the glory of being a patron, perhaps there should be some quid pro quo, some reflected duty that you owe that makes it a bargain. So this takes us to the conclusion part of the paper, which I've broken down for you here on the slide into 7 distinct areas, which I'll talk to and expand upon slightly. So the first point then, the patronage bargain encapsulates the multifaceted nature of the patron and client dyad. So what this does, or what it helps us think about then, is the patron relationship with our charities in English and Welsh charity law. It's a critical tool, a portmanteau term that encompasses a number of different elements underneath the surface, which we can examine and attack and see whether or not, with our critique, we can help explain the patron and client relationship, the dyad, more comprehensively, more clearly, to see what exactly is going on in that relationship, that key relationship in English and Welsh charity law. The second point demonstrates that the patronage bargain is a multifaceted relationship constructed from multiple views from different standpoints, embarked upon for a plethora of reasons and motivations. So of course this shows that the patronage bargain is a broad, sweeping thing in some instances that has multiple stakeholders involved in it from multiple perspectives, and that it has of course multiple elements which are to be considered. Our third point goes to part 3 of the paper, where you see that shadow directors or trustees de son tort are considered, and the paper adopts the position that it is not, that patronage is not the safe harbour where patrons can bask in kudos and mutually beneficial relationship that appears to have no negative consequences. Why? Well, because as I've just said in my previous slide, and as I'll argue now, shadow director or trustee de son tort liability might lay open a patron for potential problems in terms of culpability, depending on how they've acted. Point 4, patrons may be called to account if something goes dreadfully wrong at the charity. They are deemed to have descended into the arena and gone beyond a mere titular role. So this reinforces that point, that the patron may be culpable using the tools of shadow director liability or trustee de son tort liability. Point 5, if trustees' duties are not extended to non-trustee patrons, then the parameters of the patron's role and any legal accountability they do have must be clearly set. So there's an argument at the moment. You could say that whilst the patronage bargain helps us explain what's going on with this patron-client relationship, there of course is no clarity, legal clarity, on the nature of the patron's duties or role or any potential legal culpability. It's unclear, and that lack of clarity needs addressing. This is point 6 demonstrates patrons can no longer languish as minor footnotes or obscure passages in the murky and abstruse appendices of practitioners' texts. We need to bring them into the light so that we can see more clearly how, if at all, they should behave and perhaps be held to account. And finally, neither can patrons continue to exist solely as glamorous and distant letterhead figures with no actual substance in terms of charity governance. That's of course my own position, where I'm seeking to suggest that perhaps as part of the patronage bargain, the flow shouldn't be all one way towards the patron and kudos, that the charity itself, particularly in this current period of heightened charity governance, that the patron as an office holder might be accounted more closely involved in the day-to-day running of our charities. So if you take on the role of patron, you might expect to give something back other than just the merits that flow to you as a patron. Thank you for listening.